नहीं नहीं फाइनल why said that as a final
Pardon to mention, my lord, appellant is custody more than 10 years, my
Appellant already custody more than 8 years.
Pardon to make a mention, my lord. CR number 149 of 2015, another is 736 of 2021. Both matters, the appellants are in custody for 10 years, while offense under 302.
Give it.
Okay.
really good at those and the least corridor. 2 years ship. Yes.
Supplementary list, item number 1.
Please, my lord. My lord, here the petitioner is languishing in jail custody since 27/6/2009, near about to 15 years in custody. Initially, a FIR has been registered under section, my lord, the 324 and 307. Then it has been converted to 302 with the 506 and 201. My lord, so far the allegation of the prosecution allegation is concerned that while the accused taking his plow for cultivation of his land, the deceased also snatches away the plow, and out of anger he has also assaulted the deceased is his father, that is Ramesh Pradhan. And my lord, he has already been in custody for near about 15 years.
Your date of custody as
27/6/2009.
27/9/2009 you were forwarded to court.
Sir.
And
in month of June it will going to be completed 15 years.
15 years. And we have checked your order sheet, you are not on bail.
No.
Every time you are produced in court. And what is the allegation? It's
only allegation that when he is also taking his plow for cultivating his land, all of a sudden the plow has been snatched out by the deceased, and out of anger he has also assaulted the
by means of a tangia.
Tangia, yes.
How many blows you gave?
Multiple injuries there.
Who is the doctor?
Dr. P told 12, sir.
12.
12.
Okay.
Soumya Ranjan Naik.
About out of 12 number of injuries, external injuries, at least 9 of them are possible by that those are on head, scalp, scapula, eyewitnesses are there.
Yes, 2 eyewitnesses there. 2 are there. That is one is 7, another is 1.
Who are the eyewitnesses, Mr. Da?
We told 1, 3, and 7.
1, 3, 7. And doctor is?
Doctor is number 12.
Are the learning counsel for the petitioner, learning counsel for the state, learning counsel for the petitioner submitted that the petitioner is in judicial custody since 27/6/2009, and even though it has already been prepared, but there is no more chance of hearing of the appeal in the near future, and therefore the bail application of the petitioner may be favorably considered. Learning counsel for the state, on the other hand, oppose the prayer for bail and place the evidence of three eyewitnesses, that is PWs 1, 2, 1, 3, and 7. So also the evidence of the doctor, Secretary PW 12, who conducted post-mortem examination and noticed number of incised wound on vital part of the body, and opined that the cause of death was due to intracranial hemorrhage. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced during trial, nature of injuries sustained by the deceased, and specific overt act attributed against the appellant as per the evidence of the three eyewitnesses, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and the ratio laid down in the case of so and so, Letty versus so and so, we are inclined to release the petitioner on interim bail for a period of 3 months. So his conduct has to be ascertained by the so and so London State Council through the IIC of so and so. Okay. Yes. And there is an application for stay of realization of fine, so that is allowed.
Item 2.
May I please, your lordship? Here, the petitioner convicted under section 302 IPC for life, my lord, and inside custody, my lord, 4/4/2012.
It's a life imprisonment. Okay. 302.
My lord,
So what is the date of custody you said?
4/4/2012.
4/4/2012. So what is the name of the deceased?
Name of the deceased, my lord, Chhabbi alias Satyavrata Das.
Chhabbi alias Satyavrata Das.
My lord,
Eyewitnesses are there.
my lord,
Ki?
stated to have PW 5 and 6.
5 and 6. Eyewitnesses PW 5 and PW 6. And PM doctor?
And 11. 11, my lord.
PW 11. What are the injury sustained by this?
You know, one stab injury in the
One
leg.
single blow? No. 1, 2. Oh, 8 injuries. Oh.
PW 5. PW 5 my lord stated that one stab injury. And PW 6 my lord stated two injuries.
Hmm.
But doctor opined, my lord, some multiple injuries are there, my lord.
You are the only person present there and assaulted by means of.
And I stated that, my lord, PW 12 and PW 5 and 6 was not present at the spot, my lord. Was not present at the spot. I stated, my lord, in cross examination. May I please, my lord?
Who is the IO?
PW 12, my lord.
Which paragraph?
My lord,
that means they have not deposed as eyewitnesses to the occurrence during trial.
my lord,
Where is that line?
my lord,
Then it must
PW
prove the previous statement of those witnesses recorded under section 161 CRPC.
my lord.
Confront it and then prove it to the IO. Where is that line you have brought out? Let us see.
Cross examination, para 13, my lord.
Para 13.
My lord. 1, 2, 3, 4. Fifth line, my lord. At about 8 to 10 persons were present at the spot when I arrived there. Kalia alias Madhava Behra and Sudhakara were not present at the spot. They are the PW 5 and 6.
No, he was not. When the IO arrived at the spot, those two persons were not there. That doesn't mean that they have not seen the occurrence. Outre podun handi. Kalia alias Madhav Behra and Sudhakara were not present at the spot at the time of my arrival there.
And they did not come
to the spot during my stay there. ଠିକ ଅଛି ସିଏ ପହଞ୍ଚିଲା ବେଳକୁ ସିଏ ନଥିଲେ ଆଇଓ ବା ସିଏ ଥିବା ପର୍ଯ୍ୟନ୍ତ ମଧ୍ୟ ସେ ଆସିଲେନି ଜାଗା, how does it how do you make a submission that they are not the eyewitnesses to the occurrence? IO କଣ ଯାଇକିନି ଘଟଣା ହଉଥିଲା ବେଳେ ପହଞ୍ଚି ଯାଇଥିଲା?
And
IO received the FIR, then he reached at the spot. In the very first line it is stated that when he reached the spot and left the spot, occurrence took place at a different point of time. So what is the date time of occurrence as per the FIR?
my lord, 22/3/2012,
हाँ
22/3/2012।
22 दिन 25 दिन ना 22 दिन 25 दिन 2012 8:10 बेले घटना हला, राइट? आउ 9:15 रे इंफॉर्मेशन रिसीव हला थाना रे। आईओ रो एविडेंस होची मु जाइकिनी घटना जगह रे पहुंचली at 9:30 आ मु रहिली 3:30 पर्यंत। तो सीए आई विटनेस न रहिले कौन हे गला सेठी, से माने आई विटनेस बोली काई डिसबिलीव होबो?
PW5 my lord stated in his cross examination para 3 my lord,
ये
1 2 3 4th line my lord, many people congregated thereafter in the incident, one Musu, one Sorab and
कौन
one
जेते
Uma.
लोक सेठी थिले समस्त प्रोसिक्यूशन एग्जामिन करथांते ना कोन?
No one has been
If you are unable to demolish the evidence of 2 eyewitnesses to the occurrence, so you mean to say that it is the quantity which matters, not the quality of evidence?
and PW according to PW5
Are the learned counsel for the petitioner, learned counsel for the state, learned counsel for the petitioner submit that the petitioner is in judicial custody since 4/4/2012, and as such he has completed 12 years of imprisonment, and even though paper book has already been prepared, but there is no more chance of early hearing of the appeal in the near future. Further submits that though PW5 and PW6 have deposed as eyewitnesses to the occurrence, but the evidence of the IO bracket PW12 indicates that they are not eyewitnesses to the occurrence, and therefore there are good chances of success in the appeal, and balance of convenience is in their favor. Therefore, the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail, place the evidence of PW5 and 6, so also the evidence of the doctor PW11, who stated to have noticed number of stab wounds on the body of the deceased, and opined that the cause of death was due to syncope as a result of stab injury to the heart, and injury number 1 along with the corresponding internal injury was fatal to cause death in ordinary course of nature. Learned counsel further argued that the first information report was lost. The occurrence in question took place on 25/3/2012 at 8:10 a.m. and the information was received at Malgodown Police Station on the very day at 9:15 a.m. And the evidence of the IO bracket PW12 indicates that he arrived at the spot at 9:30 a.m. and left the spot at 3:30 p.m. And even though the IO has stated that the 2 eyewitnesses were not present at the spot, at the time of his arrival, and also they did not come to the spot during his stay there, that does not ipso facto disbelieve can be a ground to disbelieve the evidence of these two eyewitnesses. After hearing the learned counsel for both the parties, in view of the evidence of the two eyewitnesses, the evidence of the doctor, bracket PW 11, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody for more than 12 years and the ratio laid down by this court in case of so and so, we are inclined to release the petitioner on interim bail for 3 months. Marquis conduct about that. There is an application for stay of realization of fine that is allowed.
Noted.
Item 3.
May I please announce?
Yeah.
But appearing for appellant number 1, 2, 3, my lord.
Hmm.
I'm appearing for appellant number 1, 2, 3.
In the CRL number
My lord,
355.
one appeal is there. My IA is, my lord, 2284 of
No, just a minute.
2023.
355 2015.
Aye. So
How
go
many
to
appellants are there?
my lord,
Remember that you have. 355 ର appeal memo ଟା ବାହାର କରନ୍ତୁ। Appeal memo।
5 ଜଣ ସେଥିରୁ
1, 2, 3, 4, 5%.
I'm appearing for appellant number 1, 2, 3, my lord.
Just a minute. पहले 355 2015 विश्वनाथ बेहरा alias Bhila, appellant number 2 Keshav Behera alias Montu, appellant number 3 Devraj Behera alias Litu. You have filed your, what is the IA number?
My lord,
Or which case
2284 of 2023.
Huh?
2284 of 2023, my lord.
Miscase. Better put it really call the list and idea. Huh? Just put it. Is it double two? Oh, it's just later. Then what are the so many bail applications have been?
My lord,
370 of 2016 এটা কার bail application?
My lord, I am appearing on behalf opposite appellant number 4.
4. Which is your bail application?
2462.
2462. अच्छा.
others IA, my lord, may be disposed of.
So ଏଗୁଡାକ ସବୁ miscase ଗୁଡାକ dispose of
ଆଜ୍ଞା
କରାଯାଇଛି।
Yes.
ଆଜ୍ଞା dispose of।
ଆଚ୍ଛା, ଏଇଟା ଲେଖିଦିଅନ୍ତୁ miscase number 370 of 2016, miscase number 621 of 2016, miscase number 1398 of 2017, miscase number 76 of 2018, IA number 184 of 2022. Learned counsel for the appellant not want to praise these miscases, accordingly disposed of. ପାଞ୍ଚଟା ଜାଗା disposed of and not praised. Okay, now we'll take up this IA number 284 of 23.
My lord.
So these three appellants and
3 years brother, my lord.
फिर appellant ये तो बाहर करें appeal में होता just appellant number 4 मध्य file करचंती S.K. Rahul alias Sheikh Shahid. Okay, so IA 228423 here now IA
मतलब 2462
2462 of 23. Yes, Mr. Jafrullah.
My lord.
So your three appellants
My lord.
are in judicial custody since when?
My lord, they are in custody, my lord, since
13/6/2013
One date everybody was taken into custody.
my lord, they are taken into custody. My lord, 8/7/2002 or 2013.
ठीक से कौन दो? Final form दबार कर ले.
ଆଜ୍ଞା 8/7/2013 ରେ ଦି ଜଣ ଭେଲାର ମେଣ୍ଟୁ
Better बोल वाला.
हाँ।
नहीं final form दबार वाला.
जजमेंट रनिंग पे जाए सी देखो
Charge में final form.
नहीं
8/7/2013 ରେ apprehended to accuse Velar Vishwanath Vera and Montu. They were apprehended on 8/7/2013.
Wait, we have got it. So Vishwanath is taken into custody
8/7/2013.
8/7/2013.
Montu
Then
Montu भी सही दिन
Montu also same date 8/7/2013. Then Devraj same date 8/7/2013. Then S.K. Rahul S.K. Rahul तो
13/9
हाँ
13/9/2013
अच्छा हाँ 13/9. So you are granted bail during trial or in
No, my lord.
No,
all of you
Continuous
are in
custody, my lord.
trial kota divar later.
Yeah, 3 brothers, my lord. in
Just a
custody.
minute, let us see that accused persons and produced in court. Accused persons produced. You are not granted bail. Okay, during pendency of this appeal,
No, my lord.
you are never granted.
No, my lord.
So,
Entry
ଆପଣଙ୍କର ହେଇଗଲା 10 years and
10 years 10 months around, my lord. 7 months.
so far as the appellant 4 is concerned, 1 day interim bail for
1 day.
1 day.
कौन ପାଇଁ 1 day कौन ପାଇଁ ଯାଇଥିଲେ?
ବାପାଙ୍କର କ୍ରିମେସନ
अच्छा ओके 8 9 10 11
in police custody.
So more than 10 years and 6-7 months you are in custody.
7 months ହେଲେ 10 ବର୍ଷ
And
10
what is who is the deceased? What is the name of the deceased?
my lord.
କିଶୋର ବେହେରା
ଈଶ୍ୱର ବେହେରା, my lord.
Kishore Behera.
My lord.
And what is the date of occurrence?
7/7/2013
Eyewitnesses are there.
My lord.
Who are the eyewitnesses?
Eyewitnesses, my lord, PW 9, 13 and 19.
PW 9, 13 and 19.
19, my lord.
Doctor?
Doctor is PW 18, my lord.
Dr. is Millard
PM doctor.
PW 18, my lord.
18
Let us come to past PW 18. Let us see. One puncture lacerated wound. Puncture wound. So 10, 11 puncture wounds you have caused. So as per the evidence of this eyewitness, let us go to one eyewitness. PW9, let us see.
P9 examine.
My lord, think that my lord, PW9, all the witnesses, if your lordship, that it will come to the my lord, the judgment, running page that my lord, regarding examination.
Firing by pistol.
PW18, in paragraph 18, my lord, that has been discussed. My lord, these three witnesses, my lord, they were examined, my lord, belated examination
Sure,
about
that is to be appreciated.
My lord.
We are not in a bail stage.
and
Well,
PW9.
what you have done, 6 followed by 6 persons. Thereafter, a hard sounding of the firing bullet and turn back saw that one motorcycle driven by so and so, another motorcycle turning. Villain rider was sitting in the so and so. ଓ ଏଇଟା କଟକ କେସ୍ଟା କି? ଆଚ୍ଛା ୟାଙ୍କର ନାଁରେ ଇଏଟା କଣ ଅଛି କ୍ରିମିନାଲ ଆଣିବାକୁ ପଡିବ
ଆମ ନାଁରେ ନାହିଁ।
ଆସୁଆ
The deceased has my lord.
My application is only for 3 months interim bail.
let us come with it. Election ଅଛି ଆଜ୍ଞା ଚାଲିଛି IA number 2284 of 23 and ଗୋଟେ କରିଦେବା IA number 2462 of 23. Mr. Sheikh Jafrullah and counsel appearing for appellant number 1, 2 and 3 submitted that the appellants are in judicial custody since 8/7/2013. And what is your good name, Learned Counsel?
Somnath Satpathy.
Mr. Somnath Satpathy, Learned Counsel appearing for appellant number 4 submitted that he is in custody since 13/9/2013. And as such, they have remained in custody for more than 10 years and 6 months. 10 and a half years. The Learned Counsel for the state seeks some time to obtain instruction about the criminal antecedent against the appellants number 1 to 4 to the inspector in charge of who police station? Lalbagh police station. So also about the conduct of the appellants in jail custody through the superintendent of Circle Jail Chaudhar. The Learned State Council shall also obtain instruction if there is any chance of law and order situation in case the appellants number 1 to 4 are released on bail. Put up this matter. Chutti par put up this matter in the week commencing from 24th June 2024. Yes.
Item 4.
Adjust your mic.
My lord.
Appellant
is convicted under section 302 IPC and
you have filed your VNAMA.
Yes, lord.
So this your name along with this N Hathi and Mohit Agrawal. These 3 names you have filed.
Not Mohit Agrawal, N Hathi is there, my lord.
Acha, Mohit Agrawal upon acha. Lekhondu, peru the prisoner's petition at flag X for engagement of Mr. Chittaranya Sahu as the advocate. Prayer is accepted. Mr. Sahu has already filed VNAMA for the single appellant.
My lord.
Single
Yes,
appellant.
yes.
for the appellant. The name of Mohit Agrawal shall not be reflected in the cause list henceforth. Yes, now you make your submission.
Yes, my lord, the both deceased and accused are the father and son, my lord.
ये deceased होची
Father.
father.
Yes, my lord.
What is the name of the deceased?
This is my lord, Rusinath Mahakur. Rusinath Mahakur.
Rusinath.
Yes, my lord.
Rusinath Mahakur.
Yes.
And appellant is his son.
Yes, my lord.
And what is the date of custody?
We are surrendered, my lord, 24th July 2016, lordships.
24 July 2016.
Yes.
Eyewitness?
PW1 is the eyewitness, my lord. Sister of the accused.
Eyewitness PW1. She kaun habo?
Holy sister.
Sister of the appellant.
Yes, my lord.
Sister of appellant. And PM doctor is?
PW7, lordships.
So let us come to PW7. Split lacerated wound on the occipital region. 6 cm, 1 cm skin depth. Partial average and so on. So, shock and hemorrhage, head injury. Who's body level?
It's Lathi, my lord. Thengudi.
Lathi.
Yes. Certain provocation is there, and the father,
deceased asked accused as to why he is not taking or for treatment by a doctor. କାହାକୁ ନେଇକି ଯିବ?
the wife of the accused, lordships.
Wife of the accused was sleeping. ଆଚ୍ଛା ଆଚ୍ଛା। ଓ ଆପଣଙ୍କ ସ୍ତ୍ରୀଙ୍କୁ ଦେହ ଖରାପ ହେଇଥିଲା। ବାପା କହିଲେ ଯେ ସ୍ତ୍ରୀକୁ କଣ ପାଇଁ ଡକ୍ଟରକୁ ନଉନି। ସେଇଠୁ ଗୋଟେ ଠେଙ୍ଗାରେ ମୁଣ୍ଡକୁ ପାହାରେ ଦେଲେ। ଏଇଆ ତ?
My lord. It's a pick up a quarrel. Provocation thereafter. Provocation.
So କେତେ ବର୍ଷ ହେଲା କହିଲେ?
About my lord 8 years is
8 years କୋଉଠି ହେଲାଣି?
20%.
7 years.
7 years, 9 months, my lord. 7 years, 9 months, 21 days.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 24/7/2016. And the petitioner is the son of the deceased Rushinath Mahakur. And PW1, who is the sister of the petitioner, is an eyewitness to the occurrence. And from her evidence, it appears that when the deceased asks the petitioner to take her wife to the doctor for treatment as she was suffering from fever, there was some quarrel, and petitioner picked up a lathi and dealt a blow on the head of the deceased. Learned counsel submits that in view of the relationship between the parties, the surrounding circumstances under which the petitioner stated to have assaulted the deceased and the period of detention in judicial custody, the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail, place the evidence of eyewitness PW1, so also the doctor, bracketed PW7, who conducted post-mortem examination and noticed a split lacerated wound on the occipital region of the deceased and opined the cause of death is shock due to hemorrhage resulted from head injury. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced, surrounding circumstances under which the offense alleged to have taken place, committed, the relationship between the parties, the period of detention in judicial custody, absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail allowed. Yes.
Item 5.
May I break the But in here this case, my lord, both the appellants are husband and wife. They were first trial and wife is acquitted by the London trial court. And the sole appellant is the husband, my lord. The appellant, appellant number 1 is the husband, my lord. And the
Single appellant पर कहउଛନ୍ତି
single appellant, my lord.
What is the date of custody?
Custody, my lord, 13/8/2015.
And you have been found guilty under section
302, 307
302.
and 34 IPC.
कौन कहले पूरा acquittal हेगला wife पर और 34 कौन को?
Wife acquitted by the London trial court. Both were transited under section 302,
No, no,
307, 30.
conviction must be under only 302, not
302.
302
Here
either.
302. only.
Right.
Yes, ma'am.
So there is 302 and there is also 307. You are also found guilty. 5 years sentence has been imposed. What is the name of the deceased?
This is my lord, Jilli Naik. The husband, PW15 is the husband of the deceased, my lord.
PW15 is the husband of deceased
My lord.
and eyewitness to the occurrence.
Yes, ma'am. Informant also.
Who is the injured for which 307 conviction is there?
307, the one child was there. See, at the time of occurrence,
That child sustained some injury.
Some simple injury.
Okay, so let us see who is the doctor?
Dr. My lord, PW22.
PW22 doctor. PM examination. Okay, let us see that 22 evidence from Ashi.
There are 3 doctors are there, my lord.
No, no, PM doctor ki?
PW21, my lord.
PW21 deep incised wound on the right side of the neck, fracture of cervical vertebra, incised wound on the right side upper scapula. Achha. What is the weapon of offense?
Weapon of offense is axe, my lord.
Axe.
Both the appellant and the PW15 are brothers, my lord. There was a quarrel prior to the occurrence. On the said the same day evening, my lord. And the occurrence took place in the dark night at about 11 p.m. While they were sleeping. And no, there is no eyewitness. Only the solitary witness is he was also sleeping, my lord. PW15.
Accused Janako hit Jilli by an axe causing injury on the neck and posterior. Okay. They are all related to each other.
Yes, my lord. Husband and wife, the deceased and the PW15. They are husband and wife.
No, no.
And the appellant is the brother of PW15.
Oh, I see.
There was a land dispute between the parties and quarrel also happening prior to the occurrence. And he is in custody.
And you are custody since 2015.
About 9 years, my lord.
Not released on bail during trial?
No, my lord. Till now, he is in custody. Since the date of arrest, he is in custody.
Okay, let us verify that. Accused produced in custody. Okay, you are not released on bail during trial, and of course, during pendency of the appeal also, you have never been released on interim bail. Are the learned counsel for the petitioner, learned counsel for the state? Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 13/8/2015, and the deceased Jilli Naik was related to the appellant, being the brother's wife. There was a property dispute between the parties, and as per the evidence of PW15, the husband of the deceased, the petitioner stated to have assaulted the deceased by means of an axe, and who accused who faced trial along with the appellant has been acquitted, and in view of the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, placed the evidence of the eyewitness PW15, who is also the informant in the case. So also the evidence of the doctor bracket PW21, who conducted post-mortem examination over the dead body and noticed a deep incised wound on the right side neck. So also fracture of cervical vertebra and another deep incised wound on the right side of the upper scapula associated with fracture of scapular bone, and opined that the cause of death was major vessel trauma by hard weapon injuries. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced by the eyewitness PW15, the nature of injuries sustained by the deceased as per the evidence of PW21, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody and the ratio laid down by this court in so and so case, 3 months bail granted, shall not indulge in any criminal activities. Yes, and report be called for also from the local police station to the, yes. List of biology. Fine, list of data.
Weekly list passover item number 19.
So we adjourn this matter to supply the deposition copy.
Yes, yes, ma'am.
She has supplied it.
Yes.
Yes, you can have.
Lordship, the present appellant has been in custody since
Single appellant.
Yes, Your Lordship. Single.
Okay. So what is the date of custody?
4/4/2010, Your Lordship.
4/4/2010.
Yes, Your Lordship.
And you are found guilty under section
302 IPC, Your Lordship.
Okay. What is the name of the deceased?
Name of the deceased is Arthur Swain, Your Lordship.
Arthur Swain.
Yes, Your Lordship.
Date of occurrence?
3/4/2010.
Eyewitnesses are there.
Yes, Your Lordship. There are several eyewitnesses.
Who are the eyewitnesses?
PW7,
Yes.
PW10,
Hmm.
PW11,
Hmm.
PW12,
Yes.
PW 15 and PW 17.
15 and 17. And with the doctor,
PW
PM doctor?
PW 18, Your Lordship.
PW 18, let us first go to that. Cut injuries, midline head, scalp, right arm, left elbow, right axilla, right side chest. And let us say, go to one of the eyewitness, PW7.
Yes, Your Lordship.
So, read it out that main portion. What is the weapon of assault is Tangia.
Yes, Your Lordship. Tangia.
Sukanta Maji holding a Tangia. Bhagavan Maji was also holding. This man is
Sukanta Maji.
Sukanta Maji.
Sukanta. Achha. Sukanta Maji. Sukanta Maji holding a Tangia came from behind the Artha Bhagavan, directed Sukanta to assault him. On the direction of Bhagavan, Sukanta dealt 2 tangi blows on the head of Artha, causing bleeding injury. Due to such assault, Artha swine fell down on the ground, so on such. Sukant Maji again dealt another tangi blow on the right forearm. Thereafter dealt 2 other tangi blows behind the right inside. Dealt another tangi blow. Okay. So even after he fell down on the ground, also you continue to assault.
Yes, Your Lordship.
Okay.
Your Lordship, thereafter in the cross-examination,
What you stated?
I am able to see only at a distance of 50 cubits.
Trial hearing will be are you sure that you have a trial court reported you?
Yes, Your Lordship, that has been confronted to the
Final from the date of person. Nala Sukanta. 3/4/2010 राशि ठीक ଅଛି ବାକି କେଲେ ଯାଇଛି କି ନା ରସିଦ
Para 30, Your Lordship.
ହଁ ଠିକ ଅଛି କଷ୍ଟଡିରେ ସୋ ଆପଣଙ୍କର ହେଇଗଲା 14 ବର୍ଷ are the Land and Council for the petitioner, Land and Council for the state. The Land Council for the petitioner submitted that the petitioner is in judicial custody since 4/4/2010. And as such, he has remained in custody for more than 14 years. And paper book has not yet been prepared, and therefore there is no chance of early hearing. And bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and submitted that PWs 7, 10, 11, 12, 15, and 17 are the eyewitnesses to the occurrence. And they have stated as to how the petitioner assaulted the deceased Arthur Swine by a tangia repeatedly, even after he fell down on the ground. The Land Council also placed the evidence of PW18, the doctor who conducted post-mortem examination and noticed as many as 7 cut injuries on different parts of the body and opined that the cause of death was due to hemorrhage and shock and cerebral edema due to the injuries sustained. Considering the submission made by the Land and Council for the respective parties, the nature of evidence adduced by the eyewitnesses, so also the nature of injuries sustained by the deceased as per the evidence of the doctor, bracketed PW 18, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody for more than 14 years. And since paper book has not been prepared as yet, the keeping in view the ratio let down of the case of Letty versus Swanso, 3 months bail granted, report to be called for. And there is another application for stay of realization of fine that is allowed. Interim bail for 3 months. Stay. Yes.
Much obliged.
Item number 28.
Madam, I am appearing through VC, madam. I may pardon. I am appearing, my lord, in this case.
Item number 28. CRLA 179 2019. Single appellant.
My lord. My lord, may I pray, my lord? It's a case where the accused is in custody for more than 11 years. On merit, my lord, I do not want to press this case. Your lordship, since more than 11 years in custody, lordship, kindly release me for 3 months. Other cases on merit, my lord, I don't press.
What is the date when you are taken into custody?
And I was taken to custody, my lord, on 14/12/2012. 14/12/2012.
2012.
Again.
What is the offense under which you are found guilty?
My lord, 302/307. Concurrent 302 life, my lord. 307.
What is the name of the deceased?
7 years. Name of the deceased, my lord, Sanjay Kumar Mohanty.
Sanjay Kumar Mohanty. Eyewitnesses are there?
Yes, and one injured eyewitness is there.
What is the name of the, his PW?
PW1, my lord.
Vasant Kumar Padhi.
And doctor is?
PW19.
PW19.
PM doctor?
My lord.
Yes, ma'am.
219. Let us see the doctor's evidence. Okay. 1. Inside room 2, 3, fracture.
I pray for an interim bail, my lord, lordship.
Okay.
On merit, I don't press.
And what is the weapon of assault?
So it is dated Khonda. Sword.
কোটিকার ও রাজনগর আছে। Heard Mr. Dharanidhar Naik, Land Senior Advocate, appearing for the petitioner, Land Counsel for the state. Mr. Naik submitted that the petitioner is in judicial custody since 14/12/2012. It is make it 15/12/2012, and as such, he has remained in custody for more than 11 years, and there is no chance of early hearing of the appeal in the near future, as paper book has not been prepared, and therefore the petitioner's bail application may be favorably considered. While not facing the bail application of the petitioner in merit, he submitted that the petitioner may be released on interim bail. Learned counsel for the state opposed the prayer for bail, placed the evidence of eyewitness PW1, so also the evidence of the doctor PW11. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody for more than 11 years, and since the case is not ready for hearing, keeping in view the ratio laid down in the case of so and so, 3 months bail granted.
Doctor is
So PW 11 my lord.
19
19 my lord.
19, yes.
কারণ এটা 19 পর্যন্ত না yes Mr. Naik.
It's 19 only, the correction 19 my lord.
That's all right, we corrected it,
I'm
and this report has to be called for from the IAC Rajnagar.
Item 30.
Item number 3030. Mr. Vijay Kumar Mahanti J. Pradhan. সেদিন ফিরলে কি না ফিরলে
No, my lord. On the last occasion also no matter.
ছুটি আচ্ছা এটা থাও কালে আসিবে হ্যাঁ যদি আসিবে মুভ করিবে না নেক্সট
Item 33.
33
item 33 can we
tomorrow ଆପଣ ডিপোজিশন କପି ଦେଇ ଦେଇଛନ୍ତି you have collected my ଏଇଟା କାଲି ଡାକିବେ କାଲି ହେଲା ଆମର 15 ଆଜି ହେଲା 15 ହେଲେ 16 ତାରିଖ କାଲି 16/5/2020
object.
Item 35.
Mr. Niranjan Panda ଥିଲେ ପରା ପଢିଲେ house next
Item 36.
ये जो ये ଦେଖଉଛନ୍ତି display board ରେ ତ yes item 36 Rita Singh
36 wala.
Yeah.
Sir, I have to file one IA for realization of fine. That has not been filed. So after vacation, also.
you want to file and then move both the application.
Yes, ma'am.
Okay, let it go after summer vacation then. Learn counsel for the appellant submit that she intends to file an interim application for stay of realization of fine and the matter be taken off after ensuing summer vacation. Court of this matter will be commencing from 24th June 2024. If any interim application is filed for stay realization of fine, the same be tagged to the file. Okay. Yeah.
Item 39.
39 Pushpamitra Mahapatro, Ramesh Chandra Maharaj.
Please, madam.
Yes.
No, filed IA for interim bail my lord. The wife health condition is serious my lord.
IA number 775.
My lord.
You have supplied the interim application copy
Copy supply.
and medical documents have been filed.
IA 775.
Copy has not been supplied. କଣ ଆପଣ IA number ଟା କେତେ 775 ତ please come to that 775 ଆପଣ ଲେଖିଛନ୍ତି petitioner is so and so wife namely so and so is suffering from so and so care no male member but where is the medical document you have there is nothing available acha ଏଇଟା ଦେଇଛନ୍ତି next acha ଏଇଟା କଣ ହେଲା ଆପଣ I copy ଦେଇନା give the copy so that then give a receipt to them. Please give a copy in court today. So you take the instruction. We can take the 20th. All right. The Learning Council for the IN number like IN number 775 of 2024. There is an application for interim bail on the ground of ailment of the wife of the petitioner. Learned counsel for the petitioner supplied the copy
not
of the
supplied, he will
Just
supply.
let it, just office committee.
so submit that he will supply the copy of the interim application during course of the day to the Learning Council for the state, along with the medical documents. Let the Land Council for the state obtain instruction on the interim application put of this matter on 20th of May 2024.
Obliged.
Learning Council for the state shall obtain instruction about the medical condition of the wife of this. Yes. 45 this. They would have free copy the area of the town. Yes. ये connect अच्छी ବାରିପଦା ଜେଲ୍ ନା ଆଡଭୋକେଟ ଅଛନ୍ତି କହିଥିଲେ କଣ ପାଇଁ
To pardon me, Passover item 30 euros, sir. Passover item 30 euros. Day after emergency. Weekly list euros.
আমি তো কিছু আর্জন করবো না ଅଛି ডে আফটার টুমরো ଆସନ୍ତୁ
শুক্রবার আসলে
এটা মার্ক করে দিয়েছেন ঠিক আছে
Friday euros.
ঠিক আছে